Megan, you're still muted.
Okay, good afternoon, everybody. This is Megan Castle. I am the Communications Director at the Public Utilities Commission, and we want to thank you very much for joining today's informational meeting. I'm going to kick off with a few slides. And before we get started, if I wanted to encourage people, if you happen to be watching this on the YouTube channel for Public Utilities Commission, that's great. If you would like to join the Zoom, that way you would be able to ask questions. And so please do that. If you need that registration link, you can find it on the PUC calendar and register for the Zoom. You'll be able to join us, and we look forward to having you. And we do have a lot of content, so I'm going to go ahead and get started. Again, my name is Megan Castle. So for discussion and comments, when you're on Zoom, you can use your hand feature to get in the queue. And if you're joining by phone, you'll need to dial *9. You can utilize the chat feature for questions if you prefer. We would appreciate if you could include your affiliation in your Zoom name. And please say your name and affiliation before speaking. About this meeting, I just wanted to share that this workshop is being led by PUC staff, not commissioners. And the purpose of this meeting is to provide neutral education on this rulemaking, the process of the rulemaking, feedback collection, and options that members of the public have to participate in this rulemaking process. Staff can't give legal advice and are sometimes bound by law not to share opinions with public, particularly about pending adjudication. So please avoid discussing also any ongoing adjudications at the PUC. Also wanted to highlight this meeting is not intended to gather public comments. You can do that by filing them through one of the methods on our website, and we're going to talk about that in a little bit, or attend the March 4th public comment hearing. So the objectives and agenda. So the objectives are to provide information about the PUC, what the rulemaking is, and why the PUC makes rules. We will provide members of the public with information about how to submit comments during rulemaking and what they can expect during the process. And lastly, provide a brief overview of the rulemaking on Senate Bill 23-292, which was initiated by the PUC in December. And the agenda here is, you can see that, I won't read through it. I will go ahead and start the introductions of PUC staff. And I will start with Nardos Zabria. She is our senior economist at the PUC. We have Kelly Crandall, a commission advisor. And I mentioned myself, as well as there could be a few legal assistants on here to help with AV questions if there are any. And lastly, of my slides, I'd like to kick it off with introductions. And let's go ahead and I'm going to call on a person. After you give your name, affiliation, and a very brief interest in why you're attending today, then you can pick another person on here to go next. We'll start off with the PUC staff with Nardos. Would you mind going first, Nardos?
Sure. Hello, everyone. Nardos Gabragzev here. I'm an economist at the PUC, and I have been working with Kerry Crandall in this rulemaking process. I'll be sharing some information later on in this presentation.
And hi, everyone. Kelly Crandall. I'm one of the commission advisors. I've been at the PUC about 4.5 years. Looking forward to presenting to you all today and then seeing the comments in the proceeding. And perhaps maybe I can pass on to Meva.
Hi, my name is Mava Lohr, and I'm with the Labor National Union, representing our Colorado local, and we've been involved since the beginning in terms of the concept of best value employment metrics and just are looking to see that it's implemented per statute. Do you want me to call on someone else?
Yes, please do.
Okay, I will call on Brooke.
Hello, I'm Brooke Pike with Energy Outreach Colorado, and I'm a program director here. I'm curious if wanted to listen in to see if any of the rulemaking will affect any of the programs that I work on. And I don't know who's with who, but I see Phil Hayes.
Thanks, Brooke. Phil Hayes, representing IBW and the United Association of Plumbers and Pipefitters, and as well as the National Electrical Contractors Association, was one of the principal advocates working on the proponent side of Senate Bill 292.
How about Jennifer Bass?
Hi, I'm Jen Bass. I'm with Black Hills Energy, and I'm interested in learning more about this rulemaking today. Thank you. And I guess I can call on Chris.
Hi, everyone. Chris Markison. I'm the Western States Director for the Blue Green Alliance, and we work with environmental policy organizations and labor organizations to create good policy. I think our general interest is the rulemaking and how it can actually create good jobs for folks in the clean sphere. All right. I'll jump to Julian.
Julian Aguilar, IBW Local 68. Our local was one of the main proponents with Phil on this Senate Bill 23292. So just looking to see how the rulemaking process is going and how it's going to be implemented to make sure it's in line with what we had in mind for the bill. I'm not sure who's left. I think Ryan. I'll call on you.
Hi, my name is Ryan Survey, Counsel for Public Service. I'm interested in today's public presentation on the bill and hearing more about it. Thanks. And I'm not sure who hasn't spoken yet, so I'll leave it to you all to call in any outliers.
Zoe DeVito, can you go next?
Hi there. Hi everyone. I'm Zoe. I am an employee of Excel Energy in Colorado. I'm just new to the industry, and so I was just hoping to learn a little more as I go. Thank you.
Perfect. And Max K.
Hey, I'm Max with Energy Outreach Colorado. I don't know if Brooke Pike already introduced Energy Outreach, but we're an implementer for various utilities. So just seeing how this legislation impacts us.
Great. I believe that is all the people who are on the Zoom. And again, if there's other people who are watching through the YouTube channel, if you have questions or want to participate, please do go through the PUC calendar to get the Zoom link and you can join us. And with that, I believe Nardos, you will have the next section. Thank you.
Sounds good. In the next section, I'll go through the work that the PUC does and the rulemaking process and how you can participate. Many of you are familiar with this, but the PUC's mission is that the Colorado PUC aims to serve the public interest by effectively regulating utilities and facilities so that the people of Colorado receive safe, reliable, and reasonably priced service consistent with the economic, environmental, and social values of our state. There are several industries that are regulated by the PUC, including electricity, gas, steam, water, transportation, telecom, rail and transit, and gas. For the purpose of this rulemaking, we'll focus on electricity and gas. There are different ways to get involved with the Colorado PUC. You can stay informed using the PUC updates on our website. There's calendar that tracks most of the events. And also you can submit comments in multiple formats and languages. Again, that information is available on the PUC website. There are ways to join meetings that you may be interested in issues you may be interested in. These are usually in person or virtual based on the proceeding that they are happening in. And there's also a way to participate in formal proceedings through legal counsel or for yourself. And I'll go in the next few slides, I'll go explain the rulemaking process and how you can participate. What's the purpose of rulemaking at the PUC? At the high level, the rulemaking aims to set rules of general applicability for regulated utilities. It aims to hear from interested persons and parties about language changes to the rules. It sets the requirements for future cases or filings. It also aims to implement legislation where more detail may be needed. And in the process, this provides more transparency on business process by regulated utilities and the agency. So this diagram here explains or aims to kind of outline the different steps that take place in the rulemaking process. Some of you may already be familiar with this process, but this diagram kind of shows that the rules have different procedures and take time depending on the complexity of the rulemaking. The rules establish requirements for all entities, in particular industries. So rules around electric utility would apply to all of them, not just Excel or Black Hills. The same thing with gas. Before the actual formal rulemaking is initiated, the commission or staff conducts a pre-rulemaking to gather information in order to propose rules. A rulemaking will formally start when staff works with the commissioners to propose rules, which they then issue to public through a notice of proposed rulemaking. The commission may run the rulemaking or they may delegate it to a judge. In the course of running the rulemaking, the hearing officer will collect written comments about the rules and hold at least one public comment hearing where people make oral comments. There may be other workshops or hearings depending on the rulemaking and the complexities of the issues at hand, but it can depend, again, it really depends on the type of rulemaking that's taking place. There has to be a decision on the rules within 180 days of the last hearing. And the decision adapting rules is subject to other commission procedures. So people may ask for clarification or other changes that they will be considered by the commission, usually at a weekly meeting. Once the rules have been finalized, they are reviewed by the Attorney General and Secretary of State before becoming effective. In terms of timeline and getting through all of this process, the rulemaking itself can take a couple of months or even over a year once it gets started. Again, it all depends on the complexity of the rulemaking. After the rules are in effect, after the rules are effective, they will impact cases that are filed with entities. Here are some key terms to keep in mind as we go through this presentation. The notice of proposed rulemaking, the NOPR, is the first decision by the PUC that starts the rulemaking process and presents the proposed rules that participants can comment on. This, again, is available on e-filing. You can go through the document to see what's being proposed, particular for this rulemaking. Participant may mean an individual or an entity who files comments in a rulemaking. And proposed rules is referring to new rules or red lines to existing rules, which stakeholders can comment on. Also, we will talk about public comment hearing, which is a formal hearing led by a hearing officer, such as a judge or the full commission, where individuals can share comments on the rules. General information about rulemaking at the PUC. You can submit, again, comments verbally, or you can provide written comments. They're given equal weight. You do not need to have an attorney to provide comments or fully intervene in a rulemaking. In Colorado law, comments can be submitted as long as the proceeding is open, but the judge may put some deadlines around that. Some proceedings have workshops, which may be structured differently from public comments and provide additional information to those who are interested. How can you submit public comments? You can submit public comments through an online form that's available on the PUC website. You can also call and leave a voicemail at the phone number that's indicated down there in English or Spanish. You can mail your written comments to Colorado PUC, the address there. And there's also a way to email comments to Dora PUC website. Present comments orally at the public comment hearing that's scheduled for this rulemaking. It would be, when you are submitting comments, it's very necessary, or it would be very useful to have the proceeding number next to it so they are filed in the right place. In this case, it would be the proceeding number listed there. What can you expect at a public comment hearing? You do not need an attorney, as I said, to provide verbal comments. You can request an interpreter for another language, such as Spanish or sign language. At a virtual public comment hearing, people may be asked to raise their hands using Zoom, and we wait for hearing officers to recognize you to speak. You'll be asked to provide and spell your name for the court reporter who would be tracking this. You'll be asked to keep your comments within a few minutes range. And there may be a follow-up question by the hearing officer, depending on the type of comment you're providing. And hearings can end before the time listed, depending on how many people show up and how long the comments go on for. Again, this is available if you're interested in participating and not providing comments. You can also follow it on the YouTube channel. You can also request language services. The commission tries to accommodate all members of the public. And one way to do that is, by providing translation. And there is a way to request this using the form that's also on the website, or emailing Holy Vice on the email listed there. What makes for an effective public comment? I mentioned earlier, referring to the rules that you're talking about, providing alternative languages to the proposed rules if possible, and explaining why the alternative is better than what is initially proposed. Sharing specific examples or details to help us understand why you are recommending and why you're recommending the changes. Staying on topic to the proceeding and being concise and courteous of others. And I'll pause here for questions. I know Carrie Crandall is also here to answer questions.
Just giving folks another second for questions. You can also put them in the chat as we're moving forward. Well, I will go ahead and move us on. Thank you, Nardos. So this will be the largest section of the meeting. We may be, this may take less than an hour for the total meeting. So we may be wrapping up before 1 p.m., but the material is fairly complex. So my guess is we'll be pretty close to right on the dot here. So I'm going to spend some time talking about the background for the rulemaking and then some of the key concepts that were put forward in the rulemaking here. We're kind of dubbing it the labor requirements rulemaking because Senate Bill 23-292 added a number of different requirements on labor and workforce issues. The preceding number is listed there, 24R-0559EG, and I will put a direct link to that in the chat. When the rulemaking was opened up in December, it was referred to an administrative law judge, Judge Farley, and he'll be the one who will be running public comment hearings and other activities going forward, and will be issuing a proposed or a recommended decision on the rules in the coming months. So what we'll be talking about here is educational information. It's not my job to defend or justify the rules that were put forward. What we are trying to do here is to provide a bit more background and explain in a bit more plain language what was in the decision as issued to help those who want to submit comments make decisions about the kinds of things that they want to focus on and the kinds of comments that they want to provide. So we're not going to touch on everything that's in the proposed rules. And there are going to be places where there's some paraphrasing. It's not always going to be exact to legislation. So please do consult the decision, statutes, rules as needed. Just at a high level, the start of this process, we wanted to have this meeting before initial written comments are requested. The first set of comments are requested by February 5th, and then any comments responsive to that by February 21st. Followed by a public comment hearing on Zoom on March 4th, which would start at 11 a.m. And again, this session itself, we won't be taking public comments. We'll answer questions to the best of our ability. I'm going to be using two primary terms or acronyms throughout this. The first is BVE metrics, which is for best value employment metrics. Which we'll talk about going forward. I know in the past we've called it BVEM, but I think for clarity, we're going to go with BVE metrics here. And then the second one is Energy Sector Public Works Projects, or ESPW projects, which were created by Senate Bill 23-292. There have been requirements around BVE metrics starting in 2010, and those have evolved over time. The nearest impetus for this rulemaking that the Commission discusses in its decision is twofold. One is a 2022 legislative audit addressed how the Commission was evaluating best value employment metrics in various proceedings. And as a result of that audit, the Commission committed to rulemaking to help clarify the findings and how BVE metrics were used in different proceedings. Around the time the audit was finishing, or after the audit was finishing, Senate Bill 23-292 was issued. And that actually expanded the list of best value employment metrics, and it added the concept of energy sector public works projects. So the Senate bill and the legislative audit are two of the primary factors for what's covered in this rulemaking. This is a bit of the "you are here" slide. Nardos oriented everyone to the steps in a rulemaking. We are at the very beginning. Notice of proposed rulemaking has been initiated. The decision was issued at the end of December, and the first deadline for written comments hasn't come up yet. So we are at the very beginning of the process. Those of you who attended the July 2024 workshop on the legislation are going to be familiar with these two slides, but there are two major types of commission cases that we'll be referring to repeatedly in the proposed rules and in the decision. The first is an application for an electric resource plan. And there are a few steps here. First, the utility is going to submit its application for how it wants to acquire new resources to meet electricity needs. These can be of all kinds of different fuels, but the utility's application will address mono contracts, what bid information needs to be provided, how much load they're going to need and how they'll forecast it, that sort of thing. This initiates what's called phase 1 of the electric resource planning process, which is establishing the foundation for bids to be issued. And so there will generally be input by parties who get involved in the process. There will be a hearing, and then the commission issues a decision that approves, rejects, or modifies the utilities plan and may authorize them to move forward with acquiring bids. So that then moves us into phase 2 of the electric resource planning process, which, as noted, starts with the utility putting out a request for proposals, getting bids in, getting a bunch of information from bidders and evaluating that and creating a preferred portfolio, which is then submitted to the commission. And there are, again, party comments, and the commission would make a decision that approves, rejects, or modifies the group of resources the utility is looking to acquire. And that phase is generally a lot shorter. And at that point, after the commission's decision, the utility would go forward and initiate contracting or construction or other steps in the process. And then there's ongoing annual reporting that's required. And generally speaking, the rules require that electric resource plans are filed every 4 years. The second major type of the second major type of application that's discussed in the rules is a certificate for public convenience and necessity. And that's going to be, for example, for infrastructure projects that are out of the ordinary course of business. And so the utility will apply to the commission talking about what it proposes to build, roughly where, some of the costs and timelines associated with it, and they provide other information. And so similar to the electric resource planning process, there might be testimony, an evidentiary hearing, and then the PUC is going to review and address the application. And if it approves it or modifies it, then the utility can move forward with the next steps, which may include, for example, building, generation, transmission, or distribution projects. As the utility is completing the project, it will look for cost recovery, and that may occur in different proceedings or a variety of proceedings. Like with the electric resource planning process, costs may occur in a different application like a rider or a rate case, not necessarily in that application itself. And then again, depending on the decisions the commission made in approving any application, the utility could be filing annual progress reports or taking other steps. So these cases can vary a lot given the particular circumstances, but they have sort of similar set of trajectories, and we'll be talking about these types of cases throughout. When the commission issued its notice of proposed rulemaking and put out proposed rules, it also talked about 3 themes that sort of informed how it framed the decision and rules. And at a very high level, the first one is to prioritize improving existing processes. So really think about the results from the legislative audit and how Senate Bill 23-292 can be used to help shore up existing electric resource planning and CPCN requirements and make them clearer and more implementable and concrete. The second theme is to implement the legislation in ways that retain the state's legacy of robust competitive processes. And in saying this, the commission said it was thinking of situations where it wanted to ensure there's a level playing field, for example, with projects that have a project labor agreement and projects that don't have a project labor agreement. And so there are situations where the commission is looking for competitive neutrality as different bids come in. And then the third is to leverage expertise from other agencies to promote efficiency and compliance. And we have a slide that shows this later, but there are 5 different agencies that are invoked in Senate Bill 23-292 or divisions of agencies in some cases. And so we did spend some time working with the staff of other agencies in advance of the rules being issued to try to come up with some thoughtful approaches to compliance and make the process more efficient. And this is absolutely something the commission is interested in comments on. The proposed rules changes cover both the electric rules and the gas rules, get electric industry and gas industry. For both electric and gas, there are similar definitions added. There is also a labor requirements rule. And so while in previous versions of rules, best value employment metrics, for example, were redlined into the electric resource planning process, because it refers to ERPs and CPCNs and other things, there is now a separate rule that covers best value employment metrics, energy sector, public works projects, and so forth. And again, we've dubbed it the labor requirements rule. There are also modifications to the CPCN rule in both electric and gas rules. They look slightly different in one versus the other, and that's because the gas rules also include gas infrastructure planning in the CPCN rule. For the electric rules only, there is the modification of electric resource planning rules on things like the phase 1 and 2 process expectations and annual reports. And then we won't really talk about this throughout this session, but there are also some clarifying red lines where, for example, best value employment metrics were stated. Now it is referring to the labor requirements rule and creating a cross-reference. There are 3 major definitions that are put forward in the rules, and these all draw very closely from the statutes that were modified under 23-292. There is a definition for craft labor certification, which is the documentation that shows prevailing wages and so forth for energy sector public works projects. There is a definition for energy sector public works projects, which I'll talk about more on the next slide because it's a little complicated. And then there is a definition proposed for project labor agreement because that is now defined in the statutes, and it lists the factors that are included within the statutes about a project labor agreement being a pre-hire collective bargaining agreement that includes certain components. So the components of an energy sector public works project definition, I've kind of reorganized this into 4 areas. If you look at the proposed rules itself, there are multiple bullets. So, you know, this doesn't precisely match. This is more for purposes of explaining the underlying components and how they were brought forward from the legislation. So under the proposed definition, which again is something that comments can be provided on, an energy sector public works project has a purpose of generating, transmitting, or distributing electricity or natural gas to provide energy to Colorado consumers. It's built by or for a utility, including any project for which energy is purchased through a power purchase agreement or similar. In addition to purpose, it has to meet certain dollar thresholds, drawing from the statute. That includes having a total project cost of $1 million or greater, and it receives a presumption of prudence, which would be a terminology related to cost recovery at the commission, for at least $500,000 in ratepayer funding. And this decision is occurring in one of 2 venues, either in an electric resource plan or in a certificate of public convenience and necessity, one of those applications. And it meets one of the following project types, which includes power generation of greater than or equal to 1 megawatt in capacity, similar for energy storage, or is one of a specific list of types of projects that was included through Senate Bill 23-292. So the Commission's proposed rule requires all of those components to be met. And absolutely, there is a lot of nuance in the language itself. Again, this is just paraphrased. I mentioned that after the definitions, the Commission added a separate rule called the Labor Requirements Rule. And this is really intended to include information about what are best value employment metrics, and if you meet the definition of energy sector public works projects, what are the requirements for that? It doesn't only include that, but it's kind of a central, proposed as a central rule for those things. The list of best value employment metrics draws from what was in the statute with the now 6 metrics listed from Senate Bill 23-292. And then energy sector public works projects, if a project meets the definition proposed in the rules, they would also have to comply with the requirements set forth in 23-292, which are specific statutes related to apprenticeships and prevailing wages. And you'll notice this is a different title than typical commission statutes, which are under Title 40. This is these have to do with requirements that were originally set for public works projects, which are being applied to now energy sector public works projects. This is a little complicated, and I'm sorry it's so many different things on one slide at once. But I want to just talk through what the rules propose in terms of the labor requirements for electric resource plans. And then the next one we'll look at specifically for certificates of public convenience and necessity. So in the phase 1 process, the rules would require a utility to articulate what documentation it needs for best value employment metrics, how that's going to be evaluated, and then to state that it's going to reject bids that don't provide information about best value employment metrics, with a limited exception that if the project is also an energy sector public works project, it may be able to substitute compliance with that for compliance with some of the BVE metrics. Again, very much a topic that is the commission seeks comment on. If there is an energy sector public, so in an electric resource plan, in part because of the 1 megawatt nameplate capacity threshold, the proposed rules state that bids in an ERP are presumed to be energy sector public works projects, and therefore the model contracts the utility provides have to include material contract terms. If there's an exemption, and I'll talk more about exemptions in a little bit, a bidder should provide documentation for which one is being sought. Then we would move into phase 2. A utility, it would be required by rule to reject bids that fail to provide the right documentation, but also allow corrections for errors and omissions, similar to some other commission rules. And the utility should ultimately present summary information about bids to enable the commission to have public discussions about labor requirements in electric resource planning decisions. The commission itself is proposed under the rules to have to address the sufficiency of these steps in its phase 1 and phase 2 decisions. And then if the commission does approve a portfolio, the utility would be then required to let Colorado Department of Labor and Employment know about the approved projects so that they can start being ready to collect the relevant data. Again, a complex process, but hopefully it will become a little bit more apparent when you look at proposed rules. In certificates of public convenience and necessity, there are kind of 2 tracks of requirements. Pursuant to the statute, the utility has to provide best value employment metrics for generating facilities. But if that information isn't ready at the time of filing, they can be provided by a status report later. This is something that prior comments have been provided on, and I think the commission would continue to welcome comments on how to address pragmatically issues where a contract isn't signed at the time a need valuation is sought. The proposed rules would also propose to use best value employment metrics as part of the study of alternatives to the extent a utility has to provide alternative projects in addition to what it's bringing forward. Just to, as one of the potential values of BVE metrics is to look at comparisons between projects on how they perform there. For energy sector public works projects, if the project that's being brought forward is an energy sector public works project under the rules, it would need to address material contract terms with those requirements. And then should the commission approve the project, the utility would need to again notify Department of Labor Employment to begin expecting craft payroll or craft labor certification data in the future. Something that I think was challenging about working on the proposed rules is the number of different agencies and entities that are invoked with different roles in the process. The next slide, I'll show you some of the compliance options that were developed for preliminary comment. Other options and ideas are welcome here on how to streamline this process and to make it efficient between these different entities. But the first entity, of course, is the PUC itself, which would review the applications by utilities that would include actual or model contracts for energy sector public works projects. The State Apprenticeship Agency, which is commonly known as Apprenticeship Colorado in Department of Labor and Employment, also has a role in that it maintains lists of registered apprenticeships and checks graduation rates. And this is information that can be used by bidders, for example, when they're looking at meeting requirements around BVEM or energy sector public works projects. There's also the Office of the State Architect in the Department of Personnel and Administration, and they are responsible for calculating prevailing wages for different trades. And then the Division of Labor Standards and Statistics, also in CDLE, they are tasked with collecting craft labor certification information from utilities or their contractors. And there is more information that the commission included in its notice of proposed rulemaking, but this is a transition. It is new for Division of Labor Standards and Statistics to be collecting this information. And so one of the particular types of comments the commission welcomes is, what will this information look like, and can it be standardized and templatized to make this process more efficient? And then the final entity, which wouldn't generally have a role for a few years out, is the Office of the State Auditor, which under Senate Bill 23-292 would be receiving information from the PUC on the projects that are approved, and the Department of Labor Standards and Statistics on the craft labor certification data, and they would be conducting a future audit to make sure everything is compliant. Again, the notice of proposed rulemaking explains these options more, but just calling out again that the types of information that can be collected and submitted by bidders or by the utility to different entities is up for discussion, as with other parts of the proposed rules. For the State Apprenticeship Agency, they proposed a couple of options where bidders could obtain publicly available data or compliance data from them directly, and then submit that to demonstrate the connection between the apprenticeship entity and the bidder itself. For Division of Labor Standards and Statistics, an option was developed that would require utilities to annually attest that they've submitted or caused to be submitted craft labor certification. And this has to do with the commission's rules generally focusing on the responsibilities of utilities. But as I previously noted, Division of Labor Standards and Statistics is interested in any consensus proposals that could be provided to help with this data collection process. They've already posted some data collection forms and so forth on their website that are linked in the commission's decision. Some of you have probably been wondering what about exemptions, because Senate Bill 23-292 does include a number of exemptions where a project would not have to meet the requirements of an energy sector public works project in prevailing wages or apprenticeships. So for both best value employment metrics and energy sector public works projects, using a project labor agreement can be an exemption. One thing the commission included in its proposed rules, considering the theme of creating level playing field is a project labor agreement by statute doesn't address prevailing wage and apprenticeship provisions. Our understanding is that it may, regardless of whether it is written in the statute, but a project using a PLA would be required under the proposed rules to address whether it includes those terms, but not required to include those terms. There are also exemptions around the work being performed by employees of the utility service agreement signed years ago, and whether the project complies with Inflation Reduction Act requirements. And certainly that's something where it may be fruitful to particularly comment given administration changes. The commission, in writing its decision, also included a lot of general and specific questions that it thought would help create more clarity around the rules or understand variations or what it should require. Comments are welcome on a lot of different things. These are just some examples of things the commission particularly asked. And again, this is paraphrased, but just as an example, there are, in the definition of energy sector public works projects, the way the commission created the proposed rule, there are certain projects that are listed in the statute that really probably in practice wouldn't be invoked. So like an electric vehicle charging infrastructure project is listed in the statute, but it's not generally going to be tackled through an ERP or a CPCN application. And so does that create a lack of standardization around labor requirements? Should there be more standardization? And if so, how would that look? Is that something the commission should consider follow-on rules for, that sort of thing? There are also questions about, what sort of documentation should be provided for BVE metrics, because they can be sort of qualitative at times. Should a utility be allowed to accept a bid if only 5 of 6 BVE metrics are addressed? And there are a number of other more specific questions throughout the decision that comments are appreciated on to help understand, pragmatic and efficient ways of working through this. I'm wrapping up in terms of the subject matter content portion, but we'll have some time for kind of just general questions and things like that. Just a reminder that the public comment hearing will be happening on March 4th, beginning at 11 a.m. to no later than 5 p.m. with the caveat that it can end early if all the comments are collected early in the process. We will send out the slides after this. If you want to stay informed, you can receive subscriptions from the specific proceeding involved. We'll also continue to be posting key deadlines on the commission's key proceedings page, which I'll link to in the chat. And then different events, like if there are other public comment hearings that the judge schedules afterwards, that will go up on the commission's public calendar. And with that, we want to really thank you for participating. Thanks for the folks who were listening in on the live stream. Happy to answer any comments or questions that you all have about what you heard here to the extent that we can clarify anything. I'm not hearing anything. I'll hang on another minute or two here and see if anybody has any clarifying comments or questions. But again, we've really appreciated the attendance, and hopefully this is helpful to folks as you are working on responses to the proposed rules. a comment in the chat that there aren't any questions. Well, thank you all again. We appreciate it. You'll get materials after this, and we will go ahead and wrap up early. So thanks very much. Have a good rest of your day.